Thank you for joining us on this episode of Legal Angle with Emmanuel the Law Olawale. We will be talking about mediation and its roles in resolving legal disputes, whether it's civil, criminal, or any kind of dispute. My guest today is a seasoned mediator. She's been an attorney for over 30 years and she has a wide array of experience. Her name is Mary Kay Fenlon. Welcome to the show.
Thank you, Emmanuel, for inviting me today.
Thank you for coming on. And can you please tell us a little bit more about yourself?
Certainly. I was born and raised in Columbus, and I got my bachelor's degree at the highest state in criminal justice, and then went on to law school at Capital University. I then went to a short stint at the Attorney General's office, and then went to the Public Utilities Commission, where I was a hearing examiner and oversaw hearings in a lot of different utility matters and rate-making procedures. I was there for about 9 years and then went on to of counsel and then a partner at the law firm of Porter, Morris & Arthur here in Columbus. And then went in-house with AT&T and was in-house counsel doing a number of different areas of law for 18 years. I've been practicing for over 30 years now. I feel like has specialized in mediation over the years because, of course, at the PUCO, examiners mediated other examiners' cases to help speed them along. And whether it be the total case or certain issues, we would mediate for each other. And then when I was at AT&T, we were very open to, as a party to a mediation, that's how we would resolve a lot of the cases. And then I also volunteered a lot of my time to mediate cases for Columbus Legal Aid, which I still continue to do today.
Oh, thank you. You had such a wide, versatile career, and your experience is just so, so wide, You started off with your career having a bachelor degree in criminal justice.
Yes.
Did you intend to become a criminal defense attorney or a prosecutor while you were in college?
Well, in college, I did intern for the Franklin County Sheriff. I was very interested in the criminal justice system. I always wanted to be an attorney, but I always wanted to be an attorney, not just because I wanted to be a prosecutor or a defense attorney. Part of me wanted to be a police officer, but I had very bad vision. So I kind of had to rule that out. So I was looking for other ways to get into the system. And so criminal justice was really, I think, the best undergrad degree to have to ultimately become a lawyer, even though I knew that there was different, areas of law that, I could choose from, will it be criminal, civil, or even domestic.
Okay. And so you decided that you wanted to become a lawyer even before you went to college?
Yes.
Wow,
At a
that's
very young age. Yes. I had 4 brothers, but my mom was very independent, had a career in journalism and public relations, and then ultimately got into politics. But I knew I wanted that education to really open all the doors that possibly could be open for me at that time. Of course, doors are wider open for women now, but back then, there was, some possibilities I was interested in, whether that ultimately be in politics or not. But I thought law was the best way for me to, become very independent and have the choice of careers that I wanted.
Yeah, and you really made a good use of that career.
Yes.
Most attorneys are adversarial, by nature. They love to litigate, they love to argue, they love to just fight for justice in whichever way they didn't fit. You decided to become a peacemaker at some point, which is like the middle ground, to mediate, to bring people together. What inspired that decision?
I really have to go back to my time at the Public Utilities Commission. That time was when the utilities were, the law was kind of pushing utilities into becoming more, not so competitive, more open, opening the doors, opening their networks to resellers, and breaking up, the generation piece from the distribution pieces, et cetera. And so the litigation of all of those issues was very intense. And we were in hearings for weeks and weeks and weeks at a time, with stacks and stacks and stacks of documents that we were reviewing. And there were times when we would have 10 parties in front of us in a proceeding. And if we didn't have some mediation to narrow the issues down before we went into hearing, we would be in there literally for what could have been months then. So, a 4-week hearing could take the toll, because then you had to, the examiners, we had to sit down and write the orders for the commission, over 100 pages plus. So mediation was a very good way to not only downsize the dockets for us, but also to downsize those major competitive dockets that we had, and all across the board: telecommunications, gas, electric, transportation. So the laws were changing then, and I was there when the Telecom Act passed, and that certainly brought on a lot of issues as well. So mediation was a good way to downsize, but it also was a more neutral environment. The parties really spent more time thinking through about how ultimately the laws could be implemented, and didn't waste as much time arguing over and over and over. So it was a very productive way to keep all the issues managed back then.
Oh, thank you. There are people out there who might be watching this show and don't have a clue what mediation means.
Yeah.
What does it mean, and what does it entail?
Well, mediation is a way to bring parties together with generally somebody, a mediator or a facilitator, but somebody who can help bring the parties to a neutral environment where they can discuss their issues in confidentiality, and that's a very important part of it. And whatever is discussed in those matters will never be brought to court. So really the goal is to avoid litigation, whether that be significant time to save or significant amount of dollars to save by not going into litigation, or even saving emotional trauma if there are people who don't want to testify in public. So it is a very, again, a very neutral environment, and the parties first have to agree that they believe in the mediation process. And the mediator then takes on a very calm and informative role where they explain, that only one party is going to speak at a time. You're going to share each other's positions. And the mediator then is going to say, and I may break out in session. I may take The plaintiff, for example, I may take you into a different room and maybe ask you more questions so that I really, really understand your issue. And he may do that with the other party as well. He may come back with maybe one of the parties has an offer that they've never shared with each other. So this person becomes a very trusted person. No advice is given by the mediator. So they are completely neutral. And all they're doing is just encouraging the parties to bring information to, let's say, the center of the table, so to speak. And parties also have to understand that everybody has to give up a little. And, no one is going to be the winner of everything that they want. So each has to give a little in order for it to be resolved. And these could be people who are in litigation every day of the week against each other, or these could be people, let's say a repair person, a roof repair person and a customer, and they never want to see each other again for the rest of their lives. And so there could be a lot of tension there. And then for the other parties who see each other every day, they want to be able to still be friends. They still want to, be able to negotiate the next problem that they have together with the parties. So it is very, very productive for those people who want to have a different way of resolving their cases in a non-public manner.
It's a way for the mediator to facilitate conversations between people who have differing wants and needs.
Yes. Facilitating is a little bit different process. Alternative dispute resolution has many different ways to resolve. So mediation kind of generically is considered dispute resolution, but there are different roles in each of those different types. And as you study mediation and alternative dispute resolution, you learn those different roles that you can take depending on what the parties want from you.
Okay. And what types of cases can be mediated?
Any type of case can be mediated. In law in general, when there are two parties that are disputing something, most of the time parties, the lawyers are negotiating, or even the two parties without lawyers are negotiating with each other. And sometimes those negotiations just, get to a point where they just can't move anymore in an undecisive manner. And then that's why you ultimately go into court, because you just can't resolve the matter. And so that happens in every area of law. It can happen in criminal law. It can happen in any type of civil litigation, whether it be a small claims matter for $5,000 or a large civil matter in multi-million-dollar cases, a personal injury case, a contract dispute case, and also in domestic. Now, I am not I'm not allowed to mediate domestic. You have to have a special certification for that, and I've decided not to pursue that at this time. But there are domestic matters that can also be mediated, even in particular domestic disputes, disputes, even involving either children or not involving children. So those are mediated in many circumstances as well.
Thank you. Can criminal cases be mediated?
They can, but unfortunately, when you have prosecutors and defense attorneys, they know the law. They work at it every day. They know how the judges generally are going to handle. And so if you know what judge you're going to appear in front of, they know a lot more. Civil matters, when you first don't know who your judge is going to be, there's a lot of unknowns there, far more unknowns than when there is a criminal dispute. And then a lot of defendants want to have a jury trial. So you're not going to have mediation in that sense. But when I, before mediation happens, you've got negotiations happening, and prosecutors and defense attorneys are very, very practiced in negotiation, and they know how to, meet both the state in effect and the defendant's interests and needs. So it's not done nearly as often as it is in civil disputes.
It is not common in criminal procedure than it is in civil.
Right.
And what are the benefits of mediation as opposed to litigation?
Well, again, litigation is very, very time consuming. You've got interrogatories, the whole discovery process, a lot of, documentation, a lot of records that need to be gathered. Now, a lot of times mediation can occur after that discovery has had. So you may not know that how complex the matter is until after the discovery is completed. So I'm not saying that you'll never have discovery and that you can avoid discovery in all instances. Sometimes you can narrow discovery down, especially when you've perhaps mediated a couple of the issues that you would otherwise bring to the court. So sometimes you can just say, okay, we're going to resolve these two issues, or we haven't been able to resolve these, and so we're only going to, now go forward with this one issue, that a contract dispute issue that will certainly eliminate some of the time that is involved in the discovery process. And also that time means dollars. If you are, preparing for a case for months and months, you may have several attorneys involved in it, and it's very, very costly. And there are some issues, and some companies, like when I was with AT&T, we didn't want to be dragging issues into court. There were a lot of confidential matters that, yes, you can have some testimony that is kept confidential if the judge agrees to it, but still, there were so many issues that we didn't want to be dragged through court. So we were very open to dispute resolution and trying to resolve matters outside of court. There were many times when I was told, gotten a phone call, Mary Kay, resolve this, I don't want this to go to trial. So that happened a number of times.
That's good. In situations where someone has filed a lawsuit and the case is before a judge or magistrate, can the magistrate or a judge act as a mediator in trying to bring the parties together?
They can. Generally, it would be assigned to a different judge. So the judge who is going to ultimately hear the case would not be serving as the mediator. That judge may encourage the parties to try to resolve a matter. I had one of those yesterday where this really shouldn't come to hearing. You guys really need to go back and try to work this language out. It isn't something that you need me to do. And we kind of look at each other and like, you're right. But if in a situation where there is another judge that could step in, or another magistrate who could step in and serve as a mediator, that certainly is a very favorable situation. And also the courts can Franklin County is very open to mediation, and they have mediators, community mediation available. For example, where I spend a lot of time in the eviction courtroom, if you do not qualify for legal aid and you don't have your own attorney there, And let's say you are a tenant who is facing an eviction matter, and you would really like to work this out with the landlord, but there's some language that neither one of you are sure about. There are mediators. There are community mediators there that the court provides for the parties, and that's wonderful. That isn't true in all counties around the state of Ohio. So the residents of Franklin County are very fortunate to have that. And then other cases, more complex cases, the parties may, either the judge or the parties may ask for some type of mediation, and the court will, direct them to find a mediator who would be interested in helping them.
Okay. Can judges order parties to mediate?
Well, they do. It is a practice that cases should be set for mediation first. So it isn't necessarily I'm directing you parties to do this, but it's the practice of cases assigned to mediation first. That is very common.
Okay. And what should parties know before agreeing to mediate or before seeking mediation?
Well, they certainly need to understand that, again, they're not going to get everything that they're asking for the court. But what's, I think, most precious is that it is confidential. That these matters, and unless there's some type of a domestic matter where there's abuse or something like that, which would have to be reported. But I'm talking about generally in a civil matter. I think it's very beneficial for the parties to understand that this is confidential, and that if after several meetings and the parties still can't come to an agreement, they can, take their positions into court, or they can start from scratch and just say, hey, mediation didn't work. I want to start from scratch. And so whatever I said over here in mediation, that other attorney and the parties cannot bring that up in court. Again, those mediations are kept confidential, and that's very beneficial.
Thank you. In situations where the court doesn't provide the mediator and people have to select their own mediator, what should they consider when deciding who to select as their mediator?
Well, there are some mediators who specialize in certain areas, whether it be civil, criminal, and as I said, even a specialty certification for domestic. So if it is involving children or any type of other marital dispute, domestic dispute, they need to look for that certification. And then also they may want someone who certainly has years and years of practice. They may want to look to see if that mediator has, been in the courtroom, how often they're in the courtroom. Do they participate in any, overall pro bono mediation? Do they give back to the community at all? There's do they belong to the bar association or the mediation associations, either locally or at the state level? And the Columbus Bar Association is very good in allowing attorneys to name that specialty or that interest in taking on mediation cases. And so generally you can find that in the bar directory.
Yeah. Since mediation is a very confidential process, mediators will find it difficult to took their own horns to say that, well, I was able to resolve this dispute, I was able to resolve this. How are you as a mediator supposed to educate the public about your experience?
I you don't toot your horn in that sense, like, oh, I was involved in this and that. You'll hear the types of cases maybe, or again, people know my background, and that I'm particularly knowledgeable about public utilities and rates and billing issues, that type of thing. So the background says a lot. But again, we don't say, oh, well, there was this, contract dispute between these two parties. We don't do that, or should not do that. And
Yes, because of
again,
the confidential nature of it.
yeah. And now remember, most of the time when you've got two parties coming together, they're both represented by attorneys. And it's those attorneys who are parties to that mediation who will, hopefully find me as a good mediator and will use me again. And when you've got people coming back to you, okay, they must trust me. And I think that's the goal. It's not a knowledge of a particular issue, because they're the ones who are bringing the issue to you. They need to trust you, and they need to you trust your demeanor, your calmness, your ability to get parties to talk together and to ultimately, come to a decision.
Thank you. In situations where parties decide to select their own mediator without the court getting involved, who is responsible for the mediator's fee?
Well, the parties obviously have to agree to that. And there are times when there might be something in a contract between two parties that will say, hey, if there's ever a dispute, whoever is bringing that issue to the court is the one who's going to pay for that type of alternative dispute resolution. And let's take, for example, some consumer billing issues. Now you'll see that when you enter into a contract with some companies, that any alternative dispute resolution will be covered by them, but it's going to be done this way. It's going to be done through an arbitrator or a panel of arbitrators. Yes, I mean, the company will pay for it, but it's going to be done this way. So there's a number of different ways that you will see that spin. But it's generally, the parties oftentimes will split it.
Okay. And do they still have to pay the mediator's fees even if they were not able to resolve their issues at the mediation?
Yes. Again, there are some disputes that are done on a pro bono basis. If there is a nonprofit involved, you may have mediator, donate their time. Or again, if there is, if legal aid is involved, or some other organizations that are dealing with, certain qualified income people, that may be pro bono as well. There are many attorneys in town who will do mediations pro bono, but generally, yes. But I don't think there's ever wasted time in a mediation. Still, the parties have talked. They understand the issues better. I think ultimately they will save time and money, even if it does go to full litigation. It's never a waste of time.
Okay. In a situation where they went through mediation, they end up in litigation, can either of the parties call the mediator as a witness?
Oh, I've never heard of that. No, it's confidential. That is, again, now there are, and again, in domestic issues, or when there's, children involved, and you being an attorney may have some responsibility to report certain issues and may get involved with, regulatory agencies in that sense. But generally, it's confidential.
Thank you. And well, still talking about mediation and litigation. In situations where they still end up in litigation, can either of the parties seek the mediator's fees as part of the cost?
I'm sorry, can you repeat that question? Can
I said,
they?
in a situation where they still end up at trial,
Yes.
can they, as part of their relief that they're seeking from the court, can they seek the mediator's fee as part of the cost of litigation?
I've never seen that. For attorney fees, that's a good question. I have not seen that requested before. It's very possible. Those are attorney fees that had litigation costs that had been expended, but I'm not aware of that having ever been done.
Thank you. In January of last year, you started the Mary Kay Fenlon Mediation Services LLC.
Yes.
This was just 2 months before the pandemic shut down.
Yes.
How did the pandemic affect your mediation services?
Well, I had to learn how to use Zoom. um, um, and the Bar Association and the Ohio Mediation Association, and a number of other organizations, the courts slowed down. Okay. So, mediators work slowed down. But we all had the ability to learn how to mediate virtually. And it was, uncomfortable at first, especially if you had, if it was more than just two attorneys, if the attorney wanted their client there and, you got to break out, and it was kind of a technological challenge for me to set up the rooms and everything. But it worked. It worked, but certainly things slowed down when the courts were not operating. But when they got their dockets back up slowly but surely, people wanted to get back and try to mediate.
Okay. So are you back to doing face-to-face mediation right now? Or is it still virtual?
Yeah, I know I am. I'm doing some, very little. My campaign has kind of taken up most of my time right now. As you know, I'm a candidate for municipal court judge. And I also still do a lot of volunteer work, pro bono work for Columbus Legal Aid. And so that takes up a lot of time too. I'm helping them with their landlord tenant project, the TAP program.
Thank you. And what does mediation between businesses and consumers, what is it like?
Um, Again, going back to my experience being on the business side, I really, most businesses want to stay in favor with consumers. They really do. I think they really want to try to resolve a case. They want to understand the consumer's misunderstanding with the billing, which is a lot of the time what happens. It's just that they don't understand how the billing works, where all these different taxes come in, all these other subsidized issues come in. So a lot of it is just them face to face understanding each other, and it's never businesses generally do not want to be overbearing or very negative in any way with their consumers. So that's not difficult. It's two big businesses fighting it out. That's a lot more difficult.
That is good to know. And a lot of people out there may do not know the difference between mediation and arbitration. Can you educate us about the difference?
Yeah, the arbitrations are going to be where the parties bring their issues forward to. You can have a single arbitration or you can have a panel, and they operate differently. Rules are set out They can either follow national arbitration rules, or they can have a company can have their own arbitration rules. But let's take generally a panel of 3 arbitrators will have the parties come to them, maybe pre-brief the issues, write it all up so we have all the information, and you guys share the briefs, the issues with each other. You can cross-examine each other. It's almost like a mini trial. And then those 3 arbitrators will take all of that information back, and they make the decision. Now, sometimes that decision can be appealed, and take it up another ladder of arbitrators. Or if the person who brings the matter doesn't like it, then they can decide, okay, well, I'll take it to court. There's all kinds of different rules and guidelines. But generally, those 3 people or that one arbitrator are making the decision for that matter. So again, a mediator does not make any decisions for the parties, other than, each party will, talk one at a time. You will respect each other. And, these are the guidelines that we use. And that's all the instruction really that the mediator provides. There's no decision making on the mediator's part. They are completely neutral.
So the mediator helps the parties to come to a kind of compromise. The arbitrator makes a decision.
Correct. Yes. And again, consumers need to be, knowledgeable and understand what is in the contract that they sign with their company, what kind of arbitration it might be, whether it would be arbitration, or where they would take their disputes. Sometimes disputes can go straight to a regulatory agency like the Public Utilities Commission, or maybe the Attorney General's office would handle such a dispute. Or you could maybe take it to small claims court, depending on how much money is involved. So a consumer needs to be knowledgeable of what their avenues of resolution are.
You provide free representation through the Legal Aid Society of Columbus. What are those services that you provide through Legal Aid?
Well, I'm involved in their tenant advocacy program, which goes by the term TAP. And I go in and I represent the tenants who are being sued for forceful entry and retainer, and generally the landlord wants the property back and could result in eviction. And so I'm trying to, especially over this past year during the pandemic, I've been trying to advocate and try to resolve issues for the defendants or for the tenants so that they don't get evicted. And it's a great opportunity to work with the landlords' attorneys to try to come up with a resolution that, where both parties can benefit, and that they don't have to go to a judge for, a decision making. We try to come up with a solution right then before it has to go to hearing.
So thank you for doing that, because we're in a difficult time where a lot of people are finding it hard to either keep their homes or their rent or their lease.
Right.
Thank you.
Right. Thank you. It's very, very rewarding. I like giving back to the community, and it's certainly a very heartwarming way to do it.
Yes. You're also the founder and president of Rock and Roll Brain Cancer Inc.
Yes.
What is the function of this organization?
Well, I was diagnosed with brain cancer almost 20 years ago. And when I hit my 10-year survivor time, I thought, I'm going to have one heck of a party. And so my doctor at the James was in a band at the time, and he's like, oh, I'll come play for you, at your little party. And so, a bunch of friends and family got together and we had a blast. And so some of the people at the James were talking about, there's a lot of people who feel that this is, beneficial kinds of cleansing experience, and it just helps them, deal with the fact that they're, fighting brain cancer or any type of cancer. And so I thought, oh, okay, well, I'll do this every year. So we're 10 years later. Here I am, and I've raised about $175,000. It's not Pelotonian, but still, I feel good about the fact that we've been able to fund a couple fellows in the neuro-oncology department at the James and some other research projects. And it's a board that I was serving as president until I announced my candidacy for judge. There is a new president on, and I'm not out, soliciting money for the organization anymore. But I'm still, kind of a manpower there, so to speak, and take care of all the filings that need to be done. But having a 501(c), it's been very interesting process. And I've met a lot of wonderful people at the James, survivors, and also family members who have lost their spouses or children. So it's been a really interesting experience. We are going through kind of a rebranding. The rock and roll event is now just one of the events we have. We have a golf outing now. We have charcuteries. We have other health initiatives. So we're trying to work with another company, marketing company, to kind of, give us kind of the right message, which is, cure brain cancer.
Yeah. Wow. You turned your tribulation into triumph by helping others raising money for cancer research. That is quite laudable. Thank you for doing that.
You're welcome.
Yeah, you also worked as a hearing officer with the Public Utilities Commission.
Right.
What was that like? Was it like being an arbitrator, or was it like being a judge?
Well, it was truly a judicial position. Again, I worked for the state of Ohio. I was not elected, but we are assigned cases that the Public Utilities Commission, the commissioners that are also appointed by the state, and they, they make the decisions based on the record that we help create. And so there are administrative rules that the Public Utilities Commission of Ohio have that are unique to that organization, as opposed to the Ohio administrative rules, which other agencies use. That's one of the differences. And then there are some substantive rules that we also use depending on what type of utility it was before the bench. But in general, we heard disputes. We, rules of evidence, Ohio rules of evidence applied, rules of civil procedure could apply, again, depending on where they fell in line with the procedural rules that the commission had for itself. And then after the hearings, we would go through the mounds and mounds and mounds of paperwork and record and write the orders for the commissioners. Of course, they had the final say and would, ultimately sign off on those orders. But it was a very good experience, I think, in terms of learning kind of a judicial code. Things were confidential. We worked very strong on keeping matters confidential, not only amongst the parties that were before us, but even, between the teams of lawyers who were serving as hearing officers. So it was a very good experience.
And you're currently seeking public office as a judge.
Yes, I am. I am running for municipal court in Franklin County, and the election is in November 2nd. So I filed petitions back in February, and so my name will be on the ballot. And I'm running as Mary Kay Fenlon. A lot of people know me with the maiden name Ryan. So Mary Kay Ryan Mediation Services, or Mary Ryan Fenlon, attorney examiner. So I have used my maiden name quite frequently. However, the name on the ballot is Mary Kay Fenlon.
And what are those life experiences that you want voters to be aware of that you think or will help you as a judge?
That's a very good question, Emmanuel. I think I'm a very unique candidate for a number of reasons. One, born and raised in Columbus, and I have a commitment to the city. And I think that's evident in the fact that I, created the 501 to raise money at the James for cancer research. I also have served on a number of boards. I served on Ballet Met Board and Creative Living. I've been very involved in other organizations. When I was involved with Women of AT&T, I also just have a very varied background. I have, I interned with the prosecuting attorney for 2 years while I was in law school. So I handled judicial cases and traffic cases. Again, I served as a judicial hearing examiner. And then I also served in doing litigation and small claims matters while I was in-house counsel at AT&T. So I have the corporate experience, the government service experience, and the private practice, again, when I was at Porter Wright Morrison Arthur. And I think that those combinations, along with my commitment to the city of Columbus and Central Ohio, makes me a very likable candidate and somebody that I think people could really trust.
And also the fact that you've been a mediator trying to bring parties together. You've also worked as a hearing officer, which is more like a judicial position, just not elected. Do you think any of those two roles will aid you on the bench?
Will help me on the bench?
Yes, at least to inform your decision as a judge.
Oh, absolutely. I want to bring my commitment to mediation as a very legitimate way to resolve resolution to the court. I want to really encourage parties who would come before me to to hope that they looked at mediation, to seriously consider mediation. So I want to bring that experience to the bench, absolutely. And then I think also my experience as a hearing examiner will be that, there's a lot of issues here. And, why do we have so many issues? How about let's trying to mediate or go seek mediation on at least half of the issues, or whatever issues you might be able to resolve before the hearing, so that the hearing isn't taking up so much time, energy, money, etc.
Why this particular court?
That's a very good question. I am a people person. And I think also my experience with legal aid, both when I had done foreclosures some years ago, as well as doing the eviction process now, I love working with people, and municipal court is considered the people's court. It's the first step into the criminal justice system. We have the misdemeanors, we have some drug, minor drug offenses, and we have traffic offenses. But I feel like I'm the person, and I've got the experience where I can make a difference and really truly understand why are you here? What can I do to help you so that I don't see you again? And in particular, I don't want to see you again in common pleas court. So I want to understand, is there an addiction issue? Is there a mental health issue? Is there an employment issue, a housing issue in particular? So I think there's a lot of ways that we can address personal issues and the person who comes before us in municipal court. And that's why I decided that this is the court that I wanted to be a part of.
Thank you. If there's one thing that you like the voters to remember when they go to the polls in November, what will that be?
My smile, my personality, my commitment to, there's no one thing, Emmanuel, that's not fair. Okay. All right. One thing, you remember my first name, Mary Kay. That's easy to remember,
right? So for voters of Columbus, Franklin County who are watching this, don't forget Mary Kay. She is a cancer survivor. She turned tribulation into triumph, raised almost $200,000 so that other people will be able to cure or treat or research about cancer. She wants to be your judge, so go read up about her. Thank you for coming on the show. I really appreciate the time.
Thank you so much, Emmanuel. I appreciate you asking me to be a part of this wonderful afternoon. Thank you.
Thank you. And for those of you watching, thank you for joining us. Until next time, take care, stay safe, and stay blessed.